Well, hello everyone, and welcome to the first session of the Building Your Defense Expert Speaker Series brought to you by Brownlee LLP in partnership with Viewpoint Medical, Invista Forensic, and Westbridge Ventures. My name is Nabil Pir Mohammed. I'm a partner here at the Insurance Defense Group, and with me is Senior Associate Michael Thorne. We are your hosts for this six-part speaker series.
In our experience, insurers and their defense teams are quick to adopt reactionary strategies when faced with a personal injury claim. Instead of proactively building a defense, a great amount of time is spent making abstract arguments about the strength of the case that the claimant puts forward. The purpose of this series is to emphasize the benefits of proactively responding to personal injury claims by beginning to build a defense as soon as the first notice of loss is received. To do that, we've invited medical, mechanical, and investigative specialists to speak about their expertise and the ways in which they can help us bolster our positions throughout the life cycle of a claim. Notably, all of the medical experts that you will hear from over the coming months contributed to our victory in Armbruster and Nutting, where the claimant was awarded nothing for past or future loss of income and his overall claim was slashed by 40%. At the end of each session, we will address questions posed in the chat and email each of you to ensure that you receive your CIP credit. And before I throw it over to Nabil, I do have a laptop to my left where I'm going to be monitoring the questions as they come through. So if I'm looking this way, that's the reason why.
Well, thanks, Mike. So today is our first session, and we are pleased to be joined by Sandra Lee, the occupational therapist from McGregor Berger and Associates. Sandra is an occupational therapist who has practiced for over 33 years. She has extensive experience in the areas of disability management for complex catastrophic injuries, workplace injury assessment, and functional capacity evaluations. Her practice has spanned work in the public and private sectors, both in Alberta and British Columbia. She has been qualified as an expert witness in the fields of occupational therapy and functional capacity evaluations in the Alberta and BC courts. Sandra, thank you for being here.
Thanks for inviting me.
So first of all, I'll hand it over back to Mike actually to start questions off with you.
Yeah, so no pressure. You're our first guest in this six-part series. No pressure at all.
Pressure.
And we just thought that it would be good, everyone, to start by having Sandra, if you would, just telling us a bit about your professional background and what led you to occupational therapy.
Well, I became an occupational therapist a very long time ago, it seems. I started off in long-term care. I did a brief stint in acute care and then found my home in home care for a brief period of time before moving to BC, where I started up a private practice. Up there, I did some consulting work on feeding and swallowing and wheelchair prescription, and then also morphed into vocational rehab.
Oh, okay.
So I worked in heavy industry doing ergonomic assessment, workplace hardening, and those kinds of assessments for mining and forestry. So that was quite interesting. I got to ride on one of those big haul trucks that they use in mining, so that was quite a lot of fun.
And so it sounds then like the ergonomic aspect of that then would have been, you would have had some on-site work then that you were doing.
Yeah, I had my own hard hat and ear protection and steel toe boots. So yeah, I was frequently on site looking at return to work, repetitive strain injuries, and all those kinds of things. So, and helping people get back from injuries. So it was very interesting. Then I moved back here and continued with case management for catastrophic injuries, and yeah, and then now it's morphed in again into primarily medical legal work. So,
right.
But I feel that that encompasses everything that I've been doing and kind of builds on what I've done in the past. So
yeah.
Yeah.
Well, and I have no doubt then that your practical experience definitely informs what you do present day as a medical expert. Then.
Absolutely. Yeah, for sure.
Would you be able to give everybody an overview of what occupational therapy entails and the scope of practice in general for occupational therapists?
Sure. So OT is a branch of rehab medicine, which is at the tail end of post-acute injuries. So this area of medicine or health is looking at helping people to get back to their activities that they want to do. So that functional independence in either work or leisure or in the things that they do day to day. So our education is looking at not just the physical, but also the psychological, cognitive disabilities and limitations that affect somebody's ability to become independent in whatever their goals are. So,
Right.
yeah.
Okay. So looking at somebody's functional limitations and assessing the scope of those limitations and what it is that they're going to require to assist them in their day-to-day life.
Yeah, so helping someone to become as independent as possible within whatever their goals are. So
Right.
if it's return to work, if it's helping them with childcare, being independent in their home, accessing their home in cases where their mobility is limited or no longer safe in whatever capacity.
Right.
Yeah, so, and then also looking at perhaps psychological barriers that may present as challenges towards achieving any of those goals.
So in thinking about that, and then in thinking about your background, I wonder, is it the case that all occupational therapists do have some element of practical experience, or is it possible for there to be folks out there that are practicing occupational therapy that don't have actual hands-on, on-site, so to speak, experience?
I can't speak to every occupational therapist. Most, I think, will practice treatment in some perspective, obviously helping it. So there are occupational therapists in a whole bunch of different realms. There's ones in acute care hospitals, there's people in home care, there are people in psychiatric units, as well as in the community, in schools. So those are your pediatric therapists, and they look at helping kids to move through their developmental stages and moving forward. So
right.
In the medical legal realm, hopefully you are looking at people who have experience with a number of different injuries and have a broader scope. Those are helpful because you never know what kind of injuries come to your table. So
unless they're hired by the claimants, in which case we hope they don't have the experience.
maybe.
Yeah. Well, I think what everyone is wondering is what exactly is a functional capacity evaluation, an FCE?
So an FCE is an evaluation that looks at physical capacity or physical limitations or physical maximums. So we look at material handling, which is lifting, carrying, pushing, pulling, ability to manipulate objects, fine motor capacity or gross motor capacity, and then taking those functional we use standardized tests as well as observation and interviews. So those things encompass a functional capacity evaluation. And then from that, we can determine what a person's physical limitations are and what symptoms arise as a result of, and what impacts their ability to reach them as well.
Right.
Yeah.
So then what factors go into a future cost of care evaluation?
So future cost of care versus a functional capacity evaluation. So functional capacity is primarily limited to physical capacity. It looks at staying, for me, within the scope of my practice as an occupational therapist, but then looking at a life care plan, it will also incorporate all of the other medical opinions that are made available to me. So I will consider your psychologists or your psychiatrists or your physiatrists or your orthopedic surgeons. And in that scope of that assessment, we're looking at identifying needs and recommendations, not just in my own scope, but also within the scope of all the other experts that so, it's a little bit of a broader assessment, looking at not just function in the scope of their injury, but also incorporating the opinions.
So is it the case then that that the work that goes into an FCE also underlies a future cost of care report, but then you go beyond that and that's when you expand the scope of the evaluation, look at what the other medical experts are saying?
Yeah, for sure. In the FCE, we'll look at the whole entire medical record and consider those, and they'll be mentioned, but there's no identifying recommendations outside of the scope of my own practice, other than to note the
Right.
value of the medical record, for sure. There's no costs or those kinds of things identified in an FCE.
Right.
Yeah.
I know Nabil has another question for you, but before he asks it, what I'm wondering is, and some people that are tuning in may not have ever watched. You know, of course, it depends on whether the evaluation is filmed. But what would people see if they were to if a cinematographer attended, filmed the FCE? What would some people typically see you doing with the person that's being evaluated?
So a typical FCE involves an interview initially. So from that, you're looking at what led you to coming to the office. Why are you here? What are your current current symptoms? What things are presenting, and what injuries you received. So then after the interview, there's typically either some questionnaires and then looking into the actual physical test. So in the physical test, you'll see someone lift, carry, push, pull, walk, bend, manipulate objects. So those are standardized tests, and the test will vary depending on the injury. If it's upper body focused, there may be a greater number of standardized tests focused on upper body. If it's mobility focused, you may choose to focus your assessment on. So it's helpful to have some pre-knowledge in the medical record, to have those things so that you can target your assessment to the injuries.
Right.
Yeah.
So that speaks to the importance then of having a good instructional letter then.
Yes.
Right.
Yes.
Right. Yeah, absolutely. Yeah.
So then in what scenarios are you being requested to perform an FCE?
So FCEs are used in a number of ways. They are used sometimes for pre-employment testing. I've done those. Also in insurance work, you're looking at disability claims and return to work. Are there accommodations that need to be made? Are they ready for a return to work? Is there a graduated return to work possible? Or are there permanent restrictions? In litigation, we're looking at, can this person return to their pre-injury job? In what capacity if they are not able to, or can they potentially move back into that job given appropriate resources? And if they can, what kind of resources need to be in place for that to occur? And then also then looking at, is the injury, what parts of that injury are related to the accident or the incident, and what parts may be pre-existing if they are, and if there are any post-accidents or other injuries that happen unrelated after the incident in question. So for what you're being asked to assess.
Right. A couple of things you've said give rise to two questions for me. Since we're already on the topic of FCEs, I'll ask that question first. And when you're thinking about functional capacity, to what extent do hypotheticals weigh on your evaluation? And what I mean by that is oftentimes, especially when we're faced with future cost of care, part of the court's consideration in assigning a value to that claim is how might these injuries manifest themselves over time, right? Might they become worse? Might they become better? And so just in listening to your answers to the last couple of questions, it occurs to me that I don't know the extent to which you take those types of hypotheticals into consideration when you are performing a functional capacity evaluation. Do you deal with it? This is what we've got right now. This is what is in front of us, or does the development of the injuries over time weigh on your evaluation?
For sure. So I'm unable as an occupational therapist to really comment on prognosis,
right,
or causation. So I'm then reliant on the medical expert opinions located in the medicals that I receive. Those are your treating physicians or therapists,
right,
as well as the IMEs or the independent assessors that come in. But I look at where they're at today and how that impacts their ability to look, and then weighing that against what I know and what I learn or research in terms of what the job is that person is going back to. So the NOC is a standardized database which has lists of occupations and their demands. However, every job specific to an employer may be slightly different. So that's the importance of that interview section is to really parse out what specific job demands are related to that person's occupation. Then going forward, if there are in the medicals where there is potential for declining function or potential for future surgeries, then that factors obviously into the assessment and looking forward. But at the moment, what I'm looking at with regards to the FC is just where are they at today?
Right.
And if I know what the job is and looking at research and the interview and taking that all in together, then weighing that against what they demonstrate.
Right.
So, yeah.
And so then off that, that's actually a good segue because in thinking about the future cost of care evaluations, I think that kind of partly answers the same question geared towards future cost of care, the extent to which prognosis influences your evaluation. But then I also wonder, you've mentioned a few times about, you know, the importance, depending on the situation, of other medical experts' opinions. And I'm wondering, especially in the context of future cost of care, the extent to which it is important for you to be able to freely communicate with the other experts who have commented on the case, or are you able to just look at their written opinions unto themselves and without there being a need for any further discussion in your evaluations?
For the most part, I can rely mostly on the medical reports as they present. It is sometimes helpful to be able to communicate with them. So that is on a case by case. If there are some questions, it is helpful. As a defense expert, however, if hired by defense, there is limited ability for the experts to communicate back to treatment therapists. But certainly in plaintiff files, there is a greater ability to communicate back to a treatment therapist or not. So defense expert really is kind of limited to what medicals we receive and the letter of instruction.
Right, I see.
Right, that, so.
And if you feel like there's a need to speak with another medical expert that's been engaged, you'll just revert back to the folks that retained you.
Yes,
right.
Yeah, for sure.
It never occurred to me that on the plaintiff side, you would be able to have those communications with the treating
it's much
physicians.
different. Yeah, a little bit.
Okay,
Yeah.
and do you find that's common then, that when you're being engaged on the plaintiff side of things, that you are regularly or more often than not being put in touch with, or it's only if you feel it's necessary?
It's usually allowed, like the access, if I need to say contact a doctor, I can send a letter off and say, hey, I'm writing this report. Can I just get a comment on dosage of medication, dosage, prognosis, like how long do you think this is going to be needed? Is there any other recommendations? I'm certainly able to contact therapists in that capacity, or to talk to someone and say, hey, I think a home evaluation might be necessary, or can I arrange for a job site assessment? So those things are a little bit less available to the defense experts.
And so then, I don't know about you, Nabil, but that makes me wonder, does that put defense occupational therapists at a disadvantage? So when you're squaring off with an FC that's been prepared on the claimant side, if they have had the opportunity to do those things, would you consider yourself to be at a disadvantage? And if so, how do we bridge that as a defense group? What can we do to bolster, you know, your position, having been engaged by us?
Well, I hadn't thought about that. I do think that sometimes I have requested or suggested that perhaps a job site visit may be necessary because the job is very particular. And so I have gone back to the referral source, you guys or whoever, and said, hey, do you think that the plaintiff might be agreeable? And sometimes they are, and sometimes they aren't. So, yeah, absolutely. So it kind of depends.
Although if they're not agreeable, that might reveal something about the case.
Maybe, I don't know. But yeah, I have requested it on occasion and said, hey, I think it might be helpful, or hey, I think a home visit might be a good idea. Do you think you can arrange it? Do you think plaintiff would be open to that? So sometimes they are.
Okay, so that's one way we might be able to bridge the gap then. Just making those extra requests.
So I think just being able to talk to the referral source, be it plaintiff or defense, I think that it's important to be able to communicate what it is that you need to make a good report for that.
Well, as we all know, as long as we allow you to be filmed, we can pretty much, sky's the limit when it comes to evaluations.
Yes, sometimes, yeah, that is something that doesn't happen on the plaintiff side. I never get filmed. There's never a nominee or
Yeah.
filming in plaintiff reports or assessments. Yeah.
And since we're on the topic, because I know Nabil's got some other questions for you, but since we're on the topic on that topic, do you find, everybody, I think everybody listening in will agree that, sometimes you do get we do get our backs up when the plaintiff says, well, we'll let you have, Sandra take a look and undertake an evaluation, but we want to make sure we film it. Of course, I definitely get defensive over that, pun intended. And I just wonder, is there really any reason for us to feel that way, or does it not really influence what's going on your side of things?
Way back when, I used to also get my hackles up. Oh, there's somebody coming to film you, or oh, there's going to be a nominee. But I think having been filmed multiple times, it's less daunting than it used to be. A lot of times, though, it's quite helpful to be able to revisit your assessment. You can confirm what actually happened, what a client actually said. If there was some defensive or inconsistent performance or comments, you can definitely revisit that.
Right.
And sometimes that's helpful. So on the whole, I am less opposed to being filmed than I used to be.
Okay, well, you know what? I'm glad to hear you say that, because then at least maybe I don't have to get as hot under the collar every time I'm being told that has to happen, right?
Yeah.
Because it does feel like you're being held hostage sometimes, especially on the defense side of things, when they've already gotten their FCE, you want to go get yours, and they say, well, we'll only let you do it if we can film it,
Yeah, it certainly is. It's no fun to watch yourself on film, because you either look like you, I don't know, you didn't like what you wore, or maybe you said something, but it is certainly nice in some ways to be able to go back. And you can actually quote what somebody said or what you said, and say, no, I really did ask that question. It's not just a little sidebar on my little handwritten notes.
Right.
Yeah. So on the whole, and if everything goes tickety-boo, you almost forget that the video is happening. Yeah.
Okay.
Yeah.
Right on.
Sandra, just to remind you, we are being filmed right now.
Being filmed. So yes, I think actually, you sort of tend to forget that if the videographer is doing their job, they are relatively out of your face and in the corner. Same with plaintiff. If you have a nominee, they really shouldn't be participating in the assessment. They should be sitting in a corner, not interacting with the client, just letting and observing. So the camera is the same. They should be not in your face, not coming up, not making it like a documentary. It should really just be just a neutral filming of the events that occur.
Right.
And
so a couple questions. So one would be, how is a future cost of care plan actually developed? What considerations go into a future cost of care plan that you develop in cases?
So the basic process is I receive the medicals ahead of time. I'll usually take a look at probably mostly just the IMEs and any of the major reports that are located in there. That gives me kind of a heads up on to how to direct my assessment and what things I'm going to be focusing on in terms of the actual standardized tests or questionnaires that I want to be administering. And then I'll take all that data and come out with where a person is in terms of their physical functional limitations and abilities as well. So then I take a deep dive into the medicals that are there, and that includes everything. That includes all the chart notes, pre and post. It's all the IMEs and any of the expert reports in there. And then I parse out what everybody's recommending, what I would recommend as well, and then try to look at all of the opinions. If there are contrasting opinions in the IMEs, if Dr. X says Y and Dr. Z says B, I don't know. I'm not able to comment on that, but I feel that my role is to lay them out for the court and for the referral source to be able to look at them independently and say, if you agree with this, if you agree with that, this is how these costs will differ, or this is how those recommendations will differ. So it's a matter of being objective and looking at being reasonable and what is necessary, and then commenting and trying to stay in scope of what you've been asked, which is typically accident related. And so trying to look at what is what is accident related, and what is maybe acquired after the injury itself, and then laying it all out for in a concise and readable manner that's organized, so that you can take that information and use it.
Right.
Hopefully it's useful.
Yeah.
Or helpful. Yeah.
And since we're on the, I mean, folks can refer to, any kind of an FCE they've ever received, because we've got, you've got your references in there for where you obtain your information. But since we're on the topic, we've all gone through FCEs where we see the charts, we see the tables with all of the different costs.
Yep.
Kind of a two-part question. The first is, where do you get that information? And the second is, how do you make sure that it stays current, year after year? The costs associated with massage therapy, or an ergonomic chair for the workplace. Where does that come from?
I will do the research. We do the research. I'll phone somebody up. I'll phone the clinic where the client is going to therapy. I'll say, hey, what do you guys charge for massage? Or what do you guys charge to do a work hardening program? Or what does it charge? Or I'll look at Amazon and Sport Check and see how much a foam roller costs.
Okay, so it's that practical. It's just
practical.
What is the cost?
What is the current cost today?
Yeah. From the resources that are available. Yeah. Okay, I see. Yeah. So if they're going to LifeMark, you call LifeMark. What do you charge?
Yeah. But and sometimes I already know what LifeMark is because I called them last week. But it's current. It's up to date, and we'll phone the pharmacy and say, hey, you go to Shoppers Drug Mart, what does it cost for cyclobenzaprine?
Oh, there you go.
3 tons.
Okay, right on.
Yeah.
Without getting into specifics, so let's talk generalities.
Yeah.
There are studies that are quoted in FCEs and FCCs. So sometimes, especially on rebuttal reports, you will not only do a deep dive into the facts and the evidence, and maybe you disagree with a plaintiff report, but sometimes you also tend to have maybe a disagreement on the interpretation of a study. Is that something that comes up quite frequently?
My standard of practice is to fully read the studies that I use in my citations. Sometimes I have seen where the reference is made, but if you take an actual look at the full study, it seems that only the abstract is only read, and maybe in the deep dive of the actual report, there is maybe a little bit more in depth, and maybe there is some discussion to be had around whether that is a relevant source. For sure. So I try to also stay current and read what's new. So
Yeah, absolutely.
Yeah.
And is that hard to stay current in that regard, or are there, I can't speak for the insurance folks that are tuning in, but at least on the legal side of things, we have lots of databases that we can, Mondac, Canley, you name it, Westlaw, LexisNexis, we can set up subscriptions tailored to ourselves that keep us current, send us updates when there's a new case or whatever that's released. Which of course I'm subscribed everywhere.
Me too.
But you as well, right? So there are those subscription models that
for sure. There's chronic pain journals, there's your rehab journals, for sure. You can subscribe to relevant articles and try to stay current. If there's injuries that come to your plate that maybe you're unfamiliar with, I will do a lot of research and try to see what's current in terms of knee replacements, what's new these days, what's happening, before I try to make any of those recommendations. There's obviously Alberta healthcare guidelines, there's your towards optimization, which is the medical guidelines that the doctors use in terms of that. So there's always being able to refer back. Obviously, there's a team of us at my office, so there's a bunch of other therapists who are also, we have a physio and a nurse and a lot of OTs, so obviously we'll collaborate with each other and see if anybody has any experience recently with XYZ, and So it's good.
Awesome.
Yeah.
Yeah, it
we
sounds
try to-
a lot like our office, yeah.
Yeah.
You've got folks that specialize in different things. You're all kind of do similar work, but you've got different specialties and you kind of collaborate on projects.
Yeah, it's certainly helpful to have a physio sometimes when you've got an orthopedic injury. You can call them up and say, hey, what's new?
Yeah, or can you read these physio notes because I cannot read them.
I can't read anything. I don't know what they're doing.
Yeah.
Yeah.
Right on.
For sure.
All right, and then so just building off Nabil's last kind of line of questions, we'll just shift gears from the future cost of care to the loss of earning capacity. That's the big thing, of course, in the Armbruster decision. That was one of the things that folks were most interested in, was the fact that despite the upwards trend that we've seen over the years with these large loss of earning capacity / future loss of income claims, there's been such substantial awards. And then, of course, you were with us on the Armbruster matter, and there wasn't a future cost of care award, right? It was zero. And so I think something everybody would like to hear a little bit about is how you approach evaluating loss of earning capacity claims and how you view your role in the overall process.
So I've had this discussion with their therapists in our office, and I always try to remind people that the life care plan is a part of a bigger picture. Your role is what it is, and there are multiple experts around that case. And the costs in your life care plan sometimes aren't really the major negotiating point or sticking point for maybe lawyers who have hired you. Sometimes it is about loss of earnings, or can they go back to their job? And so maybe in your discussions, that is your area of expertise. That's why they hired you to do the FCE. That's what they're looking at. They're looking at physical capacity. And so your discussions around whether that person can do their job, can they sit for long enough if it's a sedentary job? Can they lift heavy enough at a heavy enough pace for 8 hours a day to do a manual labor job? So those are comments that are not necessarily identified in a care table or a cost table, but they are definitely important in your reports. So I think that's my role. Diagnoses and prognosis, if they need a second surgery, if their condition is going to deteriorate over time, those are opinions that I rely on the other experts to weigh in and help me to determine whether this is a job that a person can maintain over the long term. If the orthopedic surgeon says the back is going to deteriorate over time and they're going to have a second surgery in 10 years or 5 years, then obviously that will factor into, is this job sustainable at a heavy level? Or maybe we need to dial it back. So I take all of those opinions and then forecast that forward based on what they're demonstrating.
Right. Okay.
Yeah. So.
And then you've used the phrase life care plan a few times, just in case folks aren't familiar with that. Life care plan is synonymous with
cost of future care. Or future care costs, or any of the other terms that are out there. Right. So they are, in my opinion, the same thing. They are different than an FCE though.
Yes. Sure. Yeah.
So what specific information and evidence do you need to make a reliable and accurate assessment?
So what's really helpful is all the documents, all of them. I like them all. I can decide then whether I want to see it or not. So chart notes are good. They give pre-accident chart notes are important because that gives us a picture of how often they were seeing the doctor before, what they were seeing the doctor before, were their prescriptions prescribed prior to the accident, and what they were and in what dosage. The IMEs obviously are super important. They're the independent assessments, and hopefully they will help to guide your and specialist reports and treating therapist reports are always very helpful. So yeah, I would not edit out anything. Sometimes, because I think if you're on the stand and or being asked, and if somebody presents a document that you've not seen or considered, I think that puts you a little bit backpedaling if the opinion is different than what you came to, and you would definitely have to just reconsider that on the stand or if you were questioned. Yeah.
Okay, that makes me think one or two things. The first is, that being the case, do you, when you're being engaged by a defense team, is it preferable that you be engaged after the claim, if the claimant is going to get an FCE or a life care plan? Is it preferable that you be engaged after that so you can see what they have come up with, or does it not really make a difference?
I think if you're looking at a rebuttal in terms of life care plans, I think that it's helpful to have the other experts' life care plan presented to you. The FCE, not so much. I think that I can offer an opinion about a person's function regardless of whether there's a plaintiff report or not, but the life care plan itself, I think, is not necessarily necessary for me to have ahead of time, but I do like to have all of the other expert opinions on my plate when I write any of the reports. So
everything else
is good. Defense, or even if there's not an FCE from the plaintiff, it's not so important. I can still come to my opinion, I think, with regards to that. But,
so what challenges do you face when trying to get your hands on all the information you need to do your assessment?
Yeah, sometimes we get the medicals too late, like, or we're hounding or asking, not hounding, maybe. Sometimes we don't get them in time for the assessment, or we get them like the day of, and that's a little bit of a rush for me to at least peruse what I'm looking at. To get the letter of instruction too late and then to not be able to kind of go into that assessment prepared is a bit of a challenge. The other challenge that I come across is getting the video after.
Right.
So if you're videoed, we should be able to have that video when we write our report.
Right.
But I find that is typically a challenge, I think, and I don't think that it's necessarily yours. I think it's plaintiff has to release that back to defense, is what I understand. And I think that is the challenge. But there's many times where I've asked for the video and we wait for the video and the report is due and the video is not here, and that is super frustrating for me. And I think the other people in my office, it's always a, did you get the video? Or, oh, I'm writing another report without the video. And that can be and it is important because you agreed to be videoed. You agreed to be videoed. And so when we discuss that, we should have access to that video.
Yeah, absolutely. Nabila, you must have some comments in that regard. You know how to use the rules as a sword. What can we do to remedy that situation?
It's a challenge.
I'll have to look into it. But speaking about now specifics, Sandra, can you share with us maybe your experience in testifying at trials, especially the Armbruster case for us, the Delphs case for David Pick, without getting into specifics, just in generalities? What was your experience testifying for the defense in these trials?
So they were two very different testimonies. So Delphs was BC Supreme Court, and it was virtual. That assessment was a document review, and I didn't actually assess the person that I was writing a report for. So that may lead to another discussion later on. But an Armbruster was in person, and I did actually do the actual physical assessment with that person. So I found it helpful to be virtual and in person are very different experiences. Obviously, there's a bit of a time lag, I think, in the virtual that doesn't exist in person, and the ability to read what's happening, and that is helpful when you're doing an assessment, is to be able to read the situation, how the person's reacting, what you're observing. And so I think the same applies when you're in court or testifying. I think to be able to read the room is kind of important to forecast where the direction of the questions are coming.
Well, and so then an obvious follow-up question on that is, obviously physical examinations are not mandatory for the work that you do, but it sounds like you're about to tell us it's definitely preferable.
Definitely preferable for sure. We or I've been asked to do what we call document reviews or future cost of care projections. And those are assessments or life care plans that identify costs, but they're solely based on documents received and documents reviewed. So obviously, if push comes to shove and somebody says, well, if you had seen this, would you have changed your mind? I would obviously have to consider that.
Sounds like Armbruster with the social media.
Yeah. So yeah, it's definitely preferable to be able to see someone, but obviously if all things considered, the FCE is well done. I think they're all standardized procedures. So the data, I think, is not so much the question, it's how that data is interpreted. And what is considered reasonable costs or what is considered necessary costs. And I think that's sometimes where therapists will differ.
Right.
Yeah.
One of the themes of our speaker series is the social media aspect. I think Armbruster shed a very fine light on Armbruster's social media and how it affected the defense. Again, speaking in generalities, was that something that heavily impacted your assessment? Was it something that you went to in terms of your testimony, or was it simply a side issue?
I don't think it's a side issue. Social media is certainly something new for everybody, but I think it's another assessment tool or resource that goes into making your report. So just like the medicals are a part of it, your interview is important, the physical testing, those standardized tests that we run, and then also what your observations are and any discussions you have with any of the treating therapists if you're allowed or medical professionals. Social media, access to a person's social media is certainly another tool that if for example, if there are inconsistencies that you see between reported versus demonstrated, sometimes social media can help to parse out, where some of those discrepancies lie. And in that case, I think that it was helpful to be able to go back to that as another source of information that allowed me to be more confident in my own assessment and where I came to my decisions in terms of where I felt my recommendations were and what function.
Yeah.
So, yeah, it's just another tool. It's an important tool. It's a new tool for us to certainly look at.
Well, on that, that makes me wonder. I mean, how often are you seeing folks that are engaging you provide you with social media? I guess it would only be on the defense side. You're not getting it from the claimant side, certainly.
Yeah, I haven't seen it a whole lot. It is something new. I think plaintiff. I don't know that I've been provided with it on plaintiff side, but I guess I think if people provide it to me, I would definitely look at it. It is definitely something. It's another part of, I think, somebody's life that you see them in your office, you read about them through the medicals, and there's that other side of them that they present in their social media, and it is what they choose to present to you. So that always, you need to balance that out, because what that is maybe not the whole of their life too, but you're trying to capture as much of the whole person in your assessment as you can, and I think that part is certainly for some a very important part of their life. So I think it has value.
So on that note, one of the strategic decisions that we're often faced with is when to reveal that we've got physical or digital surveillance, right? And so it occurs to me that there is a balancing act to be had, because it might be beneficial. I don't know, this is my question to you, is would it be beneficial for you to have, and we've been talking about social media, digital surveillance, but irrespective of whether it's physical surveillance, digital surveillance, if it's something that the defense team is comfortable revealing, is it something that you could put to use during your examination? Is it something that you might have a discussion with the individual about? Or it really isn't something that you must have during the examination itself?
I don't think it's a must-have. I think, like anything, like questionnaires, they're not relied on solely to make a decision. Just like a person's subjective comments they need to be balanced against what you actually observe, against what you actually test, against what everybody else, all the experts say. So a person's personal subjective opinions and where they view themselves, just like on a questionnaire, are they perceiving where they're at consistent with what they're demonstrating? And sometimes people are right on cue. They are very introspective or have good self-awareness, and sometimes people aren't. Sometimes they overestimate their abilities and then they go to demonstrate and they're way less. And sometimes they underestimate their abilities and they demonstrate way better. And so as a therapist or as an assessor, your challenge is to figure out where that disconnect is falling apart. And so social media is a part of that ability to put those pieces together.
Right. Okay.
So I think that sort of wraps up what we had for you. I do see that there might be a notification that there are some questions that have come through the chat. Let's see if there are any.
Yeah, okay. So one of the first questions, we won't, I won't read anybody's names. I don't know, we didn't cover that, but I'll just read the questions. So one of the first question we have here is, do you review the medical records before or after the assessment? Do you prefer a summary of the alleged injuries in the instruction letter?
I do appreciate a summary. I think that helps me to just get a quick overview, and definitely I like to have the medical exam. I don't do a deep dive. I feel that part of my interview is to see where the person, what they think is important. And so sometimes what's in the medical record is what the expert thinks is important, and that's not always what the person thinks is important. So I try not to bias that interview portion by already coming into that assessment with my own ideas about what's happening. So I do like to know, though, the basics of what I'm looking at in terms of the injury, in terms of the accident basics. But yeah, I don't typically do a deep dive prior. Yeah.
So and you mentioned this earlier. So medical's definitely in the err on the side of inclusiveness.
Yes.
And it sounds like built into what you've just said, provide a summary and an unbiased summary at that.
Just give me details like, this is what happened on this day, this is what happened on that day. Yeah.
A chronology.
Yeah, just a chronology is helpful.
Okay. All right. Our next question is, if someone is claiming they can't work due to injury from a concussion/brain injury, is this considered a physical limitation and tested through an FCE, or is it the capacity evaluated by another expert?
Head injuries are very complicated. So head injuries can have both a physical and a cognitive component. So if there's a large physical component, for sure an FCE is helpful. Also looking at, so occupational therapists have, like I said, half of our education is in the cognitive psychosocial realm. So certainly we can comment on that, and that factors into our recommendations in terms of ability to organize thought or emotional resilience going into whatever it is that they want to pursue. But if you're looking at severe cognitive issues, it's best addressed in a neuropsych, in my opinion. And then the OT or the life care planner assessor can take that information and then use that as if once all of those details in terms of specifics with regards to cognitive impairment, then that can be used to help develop a rehab plan going forward. So it's not they're very complicated head injuries because of the physical as well as the cognitive component.
Right.
It can be all cognitive and no physical, and sometimes all physical, no cognitive, or some combination of the two. So I think you really need to think about what that injury is and then decide whether you're going to also have a neuropsych. And then if that's made available to the assessor like myself, then that's super helpful as well.
I'm cognizant of the time, but that gives rise to just a question in my mind. So it sounds like then the very short answer is that yes, brain injuries, cognitive deficits fall within your scope of expertise. But depending on the severity, some other expert might be required.
Yes.
You've said neuropsych a couple of times, and is there a particular reason why that is the type of specialist that comes to mind when you think about those injuries, as opposed to say, a physiatrist or a psychiatrist?
So all of those experts have different focuses. So if you're looking at cognitive deficits, particularly, is it executive functioning, memory, how much memory, in what specific capacity, those would be best addressed in a formal neuropsych assessment. If it's psychological issues, somatic symptom disorders, any of those, depression, anxiety, those are best addressed by psychologists or psychiatrists, obviously. Pain, rehab issues, those are best addressed by physiatrists. And orthopedic injuries, obviously, by orthopedic surgeons or orthopedic specialists. So I think it really depends on what injuries are presenting.
Okay.
And what experts then you want to build your case with.
Right.
Yeah.
Okay. The next question we've got 4 or 5 more here, so I'll limit my questions. The next question we've got is, great presentation. A question for Sandra. Do you have access to AHS sites where all the records are uploaded, and can you retrieve the charts?
I cannot. No, as an independent thing, as an independent assessor, I don't have access to that.
Right.
Yeah, you're, I
Is
believe.
that NetCare? Would that be?
That's NetCare. Yeah, I don't have access to that. I think your independent medical doctors can, or can they in the context of IME?
Depends if we have agreeable opposing counsel or not.
Yeah.
And we have to see what the consent order looks like.
Right.
So
yeah.
no.
So
when
no.
it depends
no.
on, we do not
When it
have
comes
their
down
consent.
to, I'm only limited to what was given to me by the referral source.
Okay.
So.
The next question is, how important are employment records? And I guess you'll want to, I suppose, answer that in the context of FCE and life care plans, right?
Yeah, I think they're important. I think a person's, sometimes a person may leave a job and we don't know why. Perhaps it's related to the injury, perhaps it's totally unrelated. So sometimes those employment records can shed light to that. There are sometimes complicating factors if there's WCB involved. So obviously WCB related claims, there's some other factors that have to be considered in that.
Right.
So obviously all the employment records are.
So it could weigh in your evaluation then if you look at someone's employment history and you see in a few different employment files that they've either been terminated for underperforming or that they've quit, that can have an influence.
Yeah, for sure.
Yeah.
It's a consideration, yeah.
Right. Okay. The next question, there is 3 more. The next one is, being on the defense side, have you ever experienced a claimant that seemed to be quote unquote faking their physical abilities?
I think most people are genuine when they come to the office. I think the disconnect typically is a client's perception of their ability versus what sometimes they demonstrate. I don't know that you can, there's a lot of things that go into why someone believes they can or can't do a task. And sometimes the litigation itself can be a hanging point, certainly. But I don't know that it's very difficult to say that anyone is truly faking it.
Right.
I think I would be reluctant. It's
anyway.
not my role to say that. I think that sometimes there are inconsistencies that don't add up, and then so I think it's up to the expert to try to lay out the facts as you see them and objectively give an opinion. But ultimately, it has to be taken in the context, I think, of everyone else's opinion as well. And I don't think it solely relies on my opinion per se, right? I think that everybody else has to weigh in, right, as well. Yeah. And
so then, is it fair to say then that even if you were to encounter someone that you thought was faking their symptoms, it isn't necessary for you to put that label on it. You look at the available evidence, you look for inconsistencies, and you just address them objectively.
Yep. Yeah, I think so. I think you can only present what a person, and if a person is truly perceiving that they can't do anything, whether it's in their head or physically they have a disability, ultimately when it comes down to them doing a task, whether it's at home or at work, they're not going to do it. So functionally, they're not doing it.
Right.
They're not doing it.
Right.
So how best then to address that? Is that best addressed through counseling or through an OT intervention in terms of trying to break down some of those barriers?
Right.
Or whatever, or rehab.
Yeah. And I would just add to that question from the legal perspective, as Nabil will attest, the difference, of course, between the medical experts, the independent medical experts and the court is that the court is the trier of fact, right?
Yes.
And it becomes the responsibility of the defense team, having questioned the claimant, completed the discovery process, to make those cases. And if the trier of fact decides that somebody isn't credible, that they're faking, then that can undermine the amount of weight that's given to their expert reports. But it isn't the place of the expert to step in and assume that responsibility.
No, I think my role that I see is to lay out all the facts as I see them. If there are conflicting reports in the medical IMEs, or if there's discrepancies that I see, then my role is to lay them out for the trier of fact to give an opinion.
Right.
Yeah.
Right. Okay, our next question is, are there different qualifications for a occupational therapist or physical therapist who completes functional capacity evaluation reports versus the occupational therapist or physical therapist who sees them in hospital or for general treatment? So I guess would that be the distinction between a treating and a non-treating physician then? Is that kind of in that question?
Yeah, I think so. I think a treating therapist has a relationship with that individual. In my opinion, if you're seeking an independent assessment, then it's best done by someone who doesn't already have some rapport or some
relationship.
The relationship. Yeah, I mean, it's not that that person can't provide an independent assessment, but I think their tendency would be to advocate, which is not the role of the independent assessment.
Right.
Yeah.
And am I right in thinking that a treating physician, or we'll contextualize it more, like a treating occupational therapist role, is it fair to say that their role isn't to provide an objective assessment of someone's capabilities, rather their role is just to ensure that they are able to live life to the fullest, that they're able to live within their limitations?
Yeah, I think the treating therapist's goal is to maximize a person's independence. They're there to facilitate and advocate and provide resources to maximize that person's independence, to help them to get to where they want to be. And sometimes want versus need can get a little mixed up when you're treating.
And you're on the need side as the independent.
Yeah, and as an independent assessor, you're looking at what's reasonable and what's necessary and what's needed. It's not necessarily what's wanted.
Right.
So I think there's a bit of a distinction.
Yeah.
That way.
You're the one with the messages that are hard to hear.
Yeah. People don't always want to hear you might have chronic pain for a long time, or it might not go away.
Right.
Yeah.
But you don't need that chair at the office.
Yeah.
Yeah. Hard to tell people.
Or a pillow.
Or the pillow.
Yeah.
Yeah.
Everybody
That's
needs
right.
a pillow.
Everybody needs a pillow. Yeah. And 2 pairs of running shoes a year every year.
Yeah.
Okay. And then the final question that we've got here, folks, is there a list of general types of questions we could or should ask when getting a functional capacity evaluation report? I often get responses of unable to answer that question.
Is there a list of questions? I guess what we're looking for when we receive a referral or is, what do you?
Might it be that it has?
Actually, sure, how to answer that.
Might it be that people need to pay a little more attention to the scope of expertise that an occupational therapist has to ensure the questions fall within?
I think so. I think if you don't know what you want, I think my best advice is to phone us or phone me or whoever you're wanting, and say, hey, I'm not sure what it is that I need. I have this person with this injury, and these are questions that I have. Is it that I need a life care plan, or do I just need the FCE? And then I think you can start that dialogue. Is it about loss of earnings? Is it about their ability to return to work? Is it about their LTD is expiring and we need to determine whether this is going into non-OC or on-OC or whatever, and are they remaining on claim or not? So having that discussion ahead of time, and if you don't know, it's best just to ask, and then we can help you and direct you whether or not, you do need a life care plan, or yes, I think you should have a home assessment, or, really, I think maybe this might need a job site assessment. Maybe we need to look at a physical demands analysis. Maybe if we can get in and take a look at the actual workplace, what the actual work demands are, or is accommodations already happening? Is accommodations even possible?
Right.
We can make recommendations and say, oh, we should have ramps and elevators put in and stuff like that. But if the workplace cannot afford it, or it's just physically not possible, it doesn't matter what I recommend. It's not a practical recommendation.
Right.
So having that discussion and saying, is it possible? Is this what you're actually looking for? Or
so,
I don't know if that answers that person's question. I hope so.
Well, it's just, I mean, I think the short answer, it sounds like this person is experiencing a little bit of frustration in that they pose questions to their occupational therapists and they either don't get a response, or the response is, I'm not capable of answering that. It sounds like McGregor Brooks' response to that is, well, have a phone call with us to begin with.
Yeah.
Before we get that instruction letter, we can talk about, you could pose, say, is this a question you can answer?
Yeah.
And then
Absolutely.
ultimately it can make its way into the report.
Yeah. Yeah, absolutely. I think having an open dialogue with your referral source, plaintiff or defense, is really important. Being able to have that ahead of time, even after, if this is what I saw,
Right.
have that discussion.
And I'll correct myself. So the time, McGregor Berger.
Yes, McGregor Berger. I was going to correct you.
Yes, my mistake.
The sign is there.
Yes.
So, Sandra, thank you very much for your time today. I think everyone really appreciates you coming down here and explaining exactly what FCEs are and everything that it entails. They can find your information on the McGregor Berger website.
Yes, so mcbahealth.com. All of our consultants are there, so you can find our bios and how to get in contact with us. So
and just a reminder to everybody as well that's tuning in, you can see a little bit of Sandra's most recent work in the Armbruster decision. If you haven't checked out that case, by all means you should. It's a good example of what can be accomplished if you adopt a proactive litigation strategy. And of course, a big part of that is engaging a robust team of specialists as the need arises. And one of those specialists in that matter was Sandra. Reminder to everybody, you will be receiving an email from us to ensure that you do receive your CIP credits for attending today, and be sure to register for all the future events that we've got coming up.
Yes, we'll say happy summer to everybody, but the next session is September 3rd with Tyler Argue, CEO of Westbridge, talking about physical and social media investigations. Thank you very much for everyone's time. Have a great summer.
Thanks, everyone.
thank you.